If you have unlawful presence in the United States, I want to say, let's talk about an I-601A waiver because maybe there's some hope for you in not having to deal with an unlawful presence bar when you leave the country to go to the consulate for your green card interview. Hi, I'm Attorney Hillary, the founding attorney at New Frontier Immigration Law, and we have done literally hundreds of I-601A waivers over my 15 years as being an immigration lawyer, and I'm excited to tell you that we've had great success, and I hope the same will be true for you. So first of all, let's talk about, do you need an I-601A waiver? And what is an I-601 waiver anyway? So if you have been in the U.S. unlawfully, so without permission, without status, for more than 6 months, you are going to face a bar when you leave the country. It's really interesting because if you stay in the country and you were able to adjust your status, you wouldn't have this unlawful presence bar. But if you leave to go get your green card, let's say in Ciudad Juarez, you are going to leave the country, and that's when the unlawful presence bar time clock would start. Like if we're turning the time thingy over, that's when the sand starts to run for the 3 years that you would be barred from the country. And we don't want to deal with that where possible. So how do we avoid that? We do what's called an I-601A waiver while you're here in the U.S. This waiver is one of the rare and really special waivers that allows you to have your waiver approved before the ground of inadmissibility arises, aka before you even leave the country. So here's how this would play out. Let's say that I'm married to a U.S. citizen, I'm Mexican, and I have been unlawfully present in the United States for, let's say, 25 years. I entered with a visa, and I just ended up staying when I was a teenager. Well, now I'm married to a U.S. citizen, and I want to get my green card. And so the way that we would go about this is I would probably adjust my status because I entered lawfully with a visa. So I would be able to adjust my status and I wouldn't need a waiver. By contrast, if I entered without permission and I was in the United States for any amount of time longer than 6 months. So in this example, let's say I entered without inspection when I was 15 years old, and now I have no lawful entry and I have all of these 15 years, more like 25 years of unlawful presence. I need to leave the country to go get my green card because I don't have a lawful entry. Before I do that though, I'm going to have my spouse file an I-130 for me. I'm going to get that approved. And then I'm going to file an I-601A and say, before I leave and before this becomes a ground of inadmissibility for me, I want you to forgive my unlawful presence, because if you don't, it's going to cause extreme hardship to my U.S. citizen spouse. The government will then approve it or deny it, and it takes about 5 years for the approval or denial to come through. So that's why it is so important for you to nail it when you file this I-601A, because you do not want to do that twice. Let's say it gets approved. Now you can open up your case in Ciudad Juarez with a DS-260, and you'll get your interview date for your green card, and you won't have to worry about your unlawful presence being forgiven at the interview because it was already forgiven before you even left the country. That's why it's called an I-601A Provisional Waiver. Now, here's the trick, and the thing that I actually hate about I-601A waivers is that you have to have a qualifying relative to show that if you don't approve this USCIS, it's going to cause extreme hardship to my family member, to my qualifying relative. And that qualifying relative cannot be your U.S. citizen children. Instead, it has to be your spouse, who is a lawful permanent resident or U.S. citizen, or your parent, who is a lawful permanent resident or a U.S. citizen. And those people need to be living inside the United States. Otherwise, your waiver is probably not going to get approved. So again, your children cannot be the basis of your waiver. So you have to have a spouse or a parent who has status in the United States. If you want help with an I-601A, please reach out to us. We know what we're doing when we do these. And then if you don't want to have to use an I-601A because you really don't want to leave the country, or if you don't have a qualifying relative for an I-601A, please reach out, because we specialize in helping people grab their papers while they're in the U.S. and not have to leave whenever possible.